Buzz along him with a slight grin. Picks apart a case where the truth's been thin. Sharp tongue firing like a rebel's hell. Justice served with a snarky spin. Nick's got the mic and is breaking it down. Lego chaos spinning all around. Laughing at the lies at the courts of crown. Riding the edge where truth is found. Coffee's cold but the witch stays hot. Poking at the holes in the legal plot. With a tilt of the glass he connects the dots. The courtroom's wild and he calls the shots. Nick's got the mic and is breaking it down. Lego chaos spinning all around. Laughing at the lies at the courts of crown. Riding the edge where truth is found. Electric strums echo through the air. Justice tangled in a legal snare. With a grin, he tears it bare. No nonsense talk for those who care.
Dun, 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 dun. Hey, I was bored, and Mo is busy, so we couldn't do more of the Delphi trial together. As it turns out, well, her kids did not rearrange the river when they went out canoeing, but they came home late, and stuff happened. So no Delphi stream today. So, ta-da! We are going to check in on Judge Simpson. I haven't done that in a while. And because I saw that last week, or this week, or what earlier this week, that there was an unusual amount of clips from his docket. So I thought I'll check it out, see if it is something, or if we find something that the rest of them didn't care about. So that is what we're doing today. Hello, folks. Hello, Turnip. Yeah, Judge Simpson kicks ass. Hope the court has decent audio. Usually, but I do have audio enhancers if there's something wrong with it. Good morning, Chadwick. Alberta. Hey, and here's from Texas. Oh, okay. So, are there loads of that in this week? Well, we will see. So, but we have this. Hold on. Gosh darn it. Oh, I'm covering too much with that one. Hold on while I check. Yeah, that's not nice either. Oh, how about that? No, covering a bit too much here. Yeah, let's try this one. Let's see how it goes, and I can rearrange. Hello, Gwendolyn. Hello. So yeah, I put on closed captions. I already have one booster on. So let's see where we get.
They had another location there. Court does call the case People versus Mohammed Diane. But before we begin, I think I need to waiver.
Good morning, Your Honor. Allie Zend on behalf of the people. Your Honor, the people would waive any potential conflict between the Honorable Court and the Office of Public Defender. While the people don't believe such conflict exists, the people make this waiver in avoidance of all doubt, Your Honor.
Thank you. Thank you, Your Honor. Assistant Public Defender Natalie Pate on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between this honorable court and our office. However, if a conflict were to wherefore arise, we would waive such a conflict.
All right. And the court for its part also does not believe there's conflict either in administrative court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter.
It's a
State of Michigan versus Deon.
Good morning, Your Honor. This is Amber Theory, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Allie Zend.
Permission to practice is granted.
Thank you, Your Honor. This is Amber Theory to the people.
All right.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Muhammad Jinan, who appears via Zoom from MDOC. Sir, could you please state your name for the court?
Do we have him?
So their camera was on. They are unmuted, but now your camera's on, Your Honor.
It sound okay for me.
Mohammed Deon.
You will
I don't
recognize
have a
him
photo.
once
I
he
don't have a
gets
picture.
on in picture. There he is.
He's on,
Oh, there he went.
and he is.
Mr. Deon, if you can hear me, please state your name.
But just in case you don't know, Judge Simpson works out of Washtenaw, Michigan. He has been a judge since 1999. He, in my opinion, is very fair. He is close to laugh. If he can help somebody, he will. But if you cross him, you're in deep shit. So, yeah.
I don't have a photo. I'm bad. I'm blank.
Yeah, I can see him.
I'm going to pass that matter.
Thank you, Your Honor.
Court does call the case of the people versus William Parker.
Allie Zend on behalf of the people, Your Honor.
Yeah, good morning, Tom Piotrowski, P40021, on behalf of Mr. Parker, who is in court today, standing to my right. Mr. Parker, identify yourself, please. Yep, my name is William Parker.
All right. What are we doing?
We are pleading per the people's offer of operating while visibly impaired second, with the understanding that Mr. Parker would be going into sobriety court as well.
So he's pleading to an added count to operating while visibly impaired second.
Yes, sir.
Correct.
Good choice.
Do I have a plea form?
Yes, sir, you do. Along with the advice of rights.
So the advice of rights, I just. You see, it was turning the other way.
This is something Judge Simpson recommends. If your client is DUIing and the evidence is overwhelming, get him or her into treatment and the court will have leniency. Now, if you come back a year or two later with another DUI, then you're really in, then you might be into deep trouble.
All right. Court's understanding is he's going to be pleading guilty to the charge of operating while visibly impaired second offense, a 1-year offense upon a successful plea to that.
Okay, this is not an, I see here, Skinrow. No, this is not a trial in itself. This is court docket. This is day-to-day what's going on in Judge Simpson's court. Now, sometimes he does have shorter trials, but this is not one of those trials that I cover. This is just, hey, here is day-to-day business, and sometimes hilarity ensues. Sometimes we see a defendant who is, oh, why don't they just throw away the key? And sometimes you see the prosecution screwing up.
Charge. Count 1 would be put full on.
Yes, sir.
May I have him sworn?
You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Lower and then state and then spell your name on it.
Yeah, William Parker. William and Parker.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired second offense. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you,
I'm sorry.
and to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not currently, no.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of February 5th, 2025, at the location of, and I've got the Carpenter Road, Pretrial Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had 4 drinks and 1 shot, Your Honor.
Okay, 4 drinks of,
Beer.
all right. Were you stopped by the police or was there an accident?
I was stopped.
Why'd they stop you?
They said I was weaving a little bit.
Okay. Are you disputing at all or contesting the right of the police to stop you in this case?
No.
All right. Were you ultimately arrested?
Yes.
Were you taken to the hospital for a blood draw?
Yes, I was.
All right. And what were the results of that blood draw?
I think it was 0.12.
We'd stipulate to that, Your Honor.
0.129.
0.29. Yes.
Yeah, that's
And so you have no reason to
way
dispute
above the
those blood
limits.
test results?
No.
All right. And sir, taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. And prior to that date, on or about October 19th, 2022, in the 48th District Court, had you been convicted of operating while visibly impaired?
Yes, Your Honor.
All right. Sir, before I accept your plea, I do have to advise you that if I accept your plea between the time of today and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any evaluation or sentencing recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, sir. No, sir.
Have I complied with the court rule, and would it be proper to accept this defendant?
Yes, sir.
Yes, Your Honor.
All right, court will accept the defendant's plea to count 2. Count 1 is dismissed.
Yeah, good choice. Good work from the attorney. Because
Defendant
Simpson
is referred
will be lenient as long as you
to Von
actually
Swartz
do the things
for an
that-
alcohol screening
that
and
you will do.
assessment and the victim's impact panel. Sentencing in this matter
Raget?
will be. Is he trying to get into a sobriety court?
Yes, and he already has been assessed, Your Honor, by Crystal Rays.
So 14B.
Yes, sir.
All right. Talk to probation as to how they want to handle that. Sentencing in this matter will be
August 27th at 12 p.m.
August 27th, 2025,
Can we
12.
make it the following week?
I don't have sentencing the following week. What's the September 10th? Would
Yes, sir. Thank you.
that work?
Yes, sir. It's 9/10, September 10th.
September 10th, 2025, 9 a.m.
Yes, sir.
Bond with its conditions will continue.
Thank you, sir.
Thank you.
Thank you.
Court does call the case of the people versus Aline Wood.
Wood?
Allie said on behalf of the people, Your Honor.
All right, next case. Nothing much to say about that case. He drove drunk, he was caught, is pleading
Good
guilty.
morning once again.
Getting
Tom
treatment.
Petrowski on behalf of Mrs. Wood. Mrs. Wood, if you would identify yourself, please, and state your name.
My name is Aileen Jane Wood.
All right, what are we doing?
I've
This is
had,
an arraignment.
I think, pretty sure she may have been already arraigned, and maybe not. We'd waive arraignment if so.
Wait, formal reading, you stand mute.
Yes, sir.
Defendant having waived formal reading, standing mute, court will enter not guilty plea.
We're in contact with Ms. Londy. We're trying to resolve this, and also we're waiting for additional discovery, some medical records that I've requested. So we just asked for an adjournment, Your Honor.
It's 6, right?
Excuse me?
Yes. All right.
Also one of these
Defendant having waived formal
day-to-day
reading, standing
cases.
mute, court will enter not guilty plea. Pretrial in this matter will be adjourned to
September 3rd.
Can we have it on the 10th as the other cases, Your Honor, or not? No? Okay. September 3rd it is.
Pretrial will be adjourned September 3rd, 2025, 9 a.m. Or as your invite indicates, as to bond in this case,
Would ask for a personal.
set the defendant's bond as a personal recognizance $5,000 bond. There is, I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's no use, no use of alcohol, recreational marijuana, or any illegal drugs.
So this old lady well, we don't really know the case since it wasn't, they waived arraignment. So we don't know the basic facts of the allegations. But if it says no assaulting behavior, okay. I did not expect that.
That's all I'll do at this point.
Thank you, sir.
Hi, Ms.
Court does
Rattle.
call the case People versus Jason Elk.
Allie said on behalf of the people, Your Honor.
May have pronounced that wrong.
And next case.
Can I get Mr. Diane back?
Yeah, folks, this is day-to-day court business in the lower courts. Next case, next case, next case. Once in a while. But I've seen Judge Simpson putting cases he thought was easy first because he thought the later ones would be the difficult ones. Oh boy, was he wrong? So, where the court is, it's in Washtenaw, Michigan. Washtenaw, Michigan.
I have not heard from the facility yet, but I did.
So,
Good morning, Your Honor. Robert Goldman, P81222, here on behalf and alongside defendant Jason Eckle. Mr. Eckle, would you please state your full name for the record?
Jason Michael Eckle.
As to the arraignment,
related to
Your Honor, for purposes of the arraignment, having had the opportunity to discuss the matter at length with Mr. Eckle, we are prepared to waive a formal reading of the complaint. Mr. Eckle will stand mute. We ask the court to enter a plea of not guilty.
defendant never waived formal reading, standing mute. Court will enter a not guilty plea at this time. What are you requesting I do with this?
Your Honor, for purposes of pretrial, we would be asking the court to set a pretrial date in this matter to give opportunity to further engage in due diligence and discussions with the prosecutor's office in an effort to resolve the matter.
Pretrial in this matter will be adjourned to
September 3rd.
September 3rd, 2025, 9 a.m. As to bond in this case, alleged BAC.
Your Honor, I have in my notes as a 0.09.
oh,
Are there other?
0.09 and then a 0.10 after, on the chemical. So 0.10.
Wow.
that's okay.
And
Still over the
this is
limit.
the second offense.
Correct, Your Honor, there was a 2021 prior.
Uh-oh.
Any accident?
No crash in this case, Your Honor.
No injuries either, Your Honor.
Set the defendant's bond, $10,000 personal recognizance bond. All other standard conditions, including no assault behavior, possession of any weapons. You are now at this time not to possess or consume any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes, Your Honor.
I am also going to order that he report over to the Department of Community Corrections for placement on a SoberLink testing device.
Yeah, second time around. Judge is getting harder on him.
And I've signed that order.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
No, I was
Court calls
thinking
case
of
of the
Damien
people
Eccles.
versus.
Isn't there an actor named Eccles with that spelling? Well, I don't think they are in Michigan. Well.
Janine Kruger.
Allie Zend on behalf of the people, Your Honor.
Next case. Let's see if it's more drunk driving.
Your Honor, Joe Simon on behalf of Ms. Kruger. Ms. Kruger, unmute and state your name, please.
Janine Kruger.
Oh,
Okay.
it's her up on the
Your
corner.
Honor, in this case, we adjourned to today so that the people could reach out to the complainant to see if some of the references in the police report are still true about a desire to proceed. That is not resolved yet, so we're asking to adjourn the pretrial one more time.
During pretrial in this matter, September 3rd, 2025, 9 a.m. Bond will continue. Thank you. Court does call the case of people versus Jillian Satori.
Allie Zend on behalf of the people, Your Honor.
Your Honor, Joe Simon on behalf of Ms. Sartori. Your Honor, state your name, Jillian, I'm sorry.
Jillian Sartori.
Thank you.
We're here for a couple of reasons. One is to address the bond violation. The court wanted levels.
Uh-oh.
The parties didn't get the published levels that I think the court has in the court file, but from my understanding, she is in fact coming down on her THC levels.
Yeah, kinda.
Uh-oh.
I think this is the one that I was thinking of. I think what happened is he went,
Bond violation.
last one. Is this the last one?
Okay.
They're backwards. Got him. Yeah, she went up and then decided to come down, so she is coming down.
Well, Your Honor, we don't have what you have, but she's been very adamant that she's been following your orders, so.
All right.
And the other thing is.
So where did the THC
Ms. Lonnie
come
was
from?
not prepared to make a resolution until we knew that answer. So we're gonna ask the court, adjourn this pretrial, but maybe we approach on one other thing real quickly.
Very quickly.
Thank you. I don't move too good today.
Okay. Sidebar. Judge Simpson not looking too impressed. Oh, he is amused.
I'll adjourn pretrial in this matter to September 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Yeah.
Bond continued. Thank you.
Judge Simpson,
Thank you, Your Honor.
you know
Court
what
calls
he's
case
thinking.
people versus.
You know what he's
Oh.
thinking. All right.
Allie Zend on behalf of the people, Your Honor.
Morning, Your Honor. David Shan on behalf
Hey,
of Brandon
Tony.
Bovee is approaching. Brandon, can you please state your name for the record?
Brandon Bovee.
I believe this is arraignment and pretrial, Your
Yes,
Honor,
sir.
so we'll waive formal reading. Defendant will stand mute.
Defendant every way formal reading standing mute. Court will enter not guilty plea.
Your Honor, we don't have any discovery in this at all, so we're going to have to adjourn it. And I also have another wrinkle, but we can address that with bond as well.
Pretrial in this matter will be adjourned then to September 3rd.
That's the wrinkle.
Okay.
This is a second for him.
Yes.
He lives in Lenawee County
Where?
in Deerfield.
Lenawee County?
Yes.
Sorry to hear that.
I
No, go ahead.
Middle of nowhere.
because of this is a second, he will qualify for sobriety court. And Judge Shadler, I do an open talk for her every year, her graduating class, she owes me. So I would like,
Wow.
she does, 9 years in a row, she owes me.
I know.
She
Yo,
does.
you had to
I want to see, well, as soon as I heard that, I turned around because I want to see that conversation.
So we're going to need more time after
You
that.
have to call down.
I know.
You owe him.
She told me herself that she owes me, so I'm not speaking out of school.
Okay.
But I think we're gonna need the next available date in order to make sure that he qualifies, get him screened and assessed, have the plea entered here, and then be able to transfer to there. So if that's whatever the next available date is after the 3rd of September.
After the 3rd. September 17th,
That would be wonderful.
2025, 9 a.m. or as your invite indicates. Alleged BAC in this matter?
Your Honor, it was a .129.
Uh-oh.
Okay. He has a prior.
Okay, a
on this.
lot of DUI.
Yeah.
cases.
He had it first a couple of years ago, so
And the prior was 2021, Your
Got it.
it has to be released in the PR bond. I know you're gonna order SoberLink and he would be fine with that.
Bond will be set in the amount of a $15,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. You are to report over to the Department of Community Corrections for placement on a SoberLink testing device.
Yeah.
Thank you.
Right here, I'll take it. Thank you, Your Honor.
So this is his second time. He
Court
does
does
not
call the
want to
case, People
come back
versus
as the
Eric
third
Casey.
one.
Alexander, on behalf of the people, Your Honor.
Good morning, Rob Jekyll on behalf of Mr. Casey, who's approaching the bench. Eric, would you state your name?
Eric James Casey.
Judge, we have continuing possible settlement negotiations with Ms. Londe. I'm asking for an adjournment.
Adjourn the matter to September 3rd, 2025, 9 a.m.
Thank you. Your
And the
Honor.
bond will continue. Thank
I
you.
want to say also, I want to thank you on, if you remember Tanya Hall, thank you for recalling the warrant.
I did that.
You did that. You're the kind and considerate judge I know.
And tell him you're welcome. Anyway, court calls the case. People versus Jennifer Gallara.
Alexander, on behalf of the people.
Good morning, Martha.
Yeah, this is one of the things. In the middle of all the seriousness, you can tell everybody respects each other in this courtroom. Because they know they do not want to piss Judge Simpson off, because he will nuke your ass if you're being disrespectful. But as long as you keep it simple, keep it going, he will work with and for you.
Of Oils, P86438, on behalf of Ms. Gallara. Will you state your name, please? Jennifer Gallara.
All right. As to the arraignment on this, you wait for a reading. Your client stands mute.
Yes, Your Honor.
Defendant have a wait for a reading, standing mute. Court will enter a not guilty plea. What are you requesting? I do need an additional pretrial date.
Yes, please, Your Honor.
Pretrial will be adjourned in this matter to September 3rd, 2025, 9 a.m. or as your invite indicates. Then as to bond alleged BAC in this matter.
Your Honor, I have a .187, and this is a first offense.
0.187.
Correct.
Oh,
Any accident?
No, Your Honor.
3 times the limit. Uh-oh.
Set the defendant's bond at a personal recognizance $20,000 bond. I'll order
Yeah.
standard conditions, including no assaultive behavior or possession of any weapons. You understand that, ma'am?
Yes, Your Honor.
There's also not to be any possession of any alcohol, recreational marijuana, or any illegal drugs. You understand that? The level in this case, I am going to order that you report over to the Department of Community Corrections for placement on a SoberLink testing device. You're to do that within the next 24 hours.
Yeah, and as you notice, if it's just over the limit, low bond. If you're 3 times the limit, bond is getting up. And if it's your second time here, oh, yep.
Probably would be your best bet to head over there right after this hearing.
Yes, Your
Okay. And I've signed that order. Anything else?
No, Your Honor.
All right, thank you.
Thank you.
Court does call the case of the People versus Robert Stevens.
Mr. Stevens is or not, Mr. Michael Gadd is attorney. And private attorney. Mr. Lauren Brown. So you can see any reason why.
So I don't know. What do you mean?
Mr. Gaddy is listed as the attorney of record.
I see that.
Mr. Lauren Brown indicated that there's no reason the PD should have to conflict out.
So it's a PD case.
But Mr. Gaddy is the attorney of record as now. It's the first time it's. I'm sorry. I don't believe Mr. Gaddy.
Well, if he's
Neither of them
appearing in
is.
his own personal capacity, I don't, the PD, that doesn't help me. Do you know where Mr. Gaddy is?
No, Your Honor, I think he might honestly be off this week, but don't quote me on that. He was
That
off, yeah.
he may be off, but he's listed personally as the attorney of record. And not the PD's office.
That was my understanding.
Okay, so not the public defender's office, it's a private.
I'll adjourn this matter
attorney.
September 3rd, 2025, 9 a.m. Court does call the cases of the people versus Rick Artuso, 3 cases.
3 cases.
People, Your Honor.
Public Defender Natalie Pate on behalf of Mr. Rick Artuso on the cases ending in 1656 and 1657.
Good morning, Adam. Please, Honorable Court, David Burgess, on behalf of Rick Artuso, as to the room.
Mr. Artuso, can you turn on your camera and unmute and state your name?
Rick Artuso.
Turn on your camera.
I'm trying to figure out how to do it.
Still started yesterday.
Yeah.
Anyway.
I'm trying to figure out how to do it. I gotta.
Dun, dun, dun.
Your Honor, I can say that it's definitely his voice.
Yeah.
He's got it.
Yeah, okay.
All right. So what are we doing?
Your Honor, there's a few pending matters, one's at circuit at this point, and we're trying to, and the prosecutor's office did mention some potential other charges, but they weren't sure that they were gonna come in, so we're trying to globally resolve them, I guess, in a nutshell, Judge. So I was just gonna suggest we adjourn the pretrial out so that we can resolve it, most likely at the circuit court case with these cases following, so.
So I was going to respectfully request an adjournment as well, Your Honor. There is an offer to resolve both of these 2 misdemeanor cases that I did attempt to reach Mr. Artuso to discuss, but I do need to relay that offer to him, so I'd be correct requesting an adjournment.
Okay, and these other cases, when is the next circuit court pretrial date, do you know?
1 second, sorry. Believe it's this afternoon. I think it's this afternoon.
Oh, it's sometime soon.
It's this afternoon at 1:30, Judge. That's why I couldn't remember the
Got
date.
it.
Sorry, yeah.
Okay,
It's Judge Hamud, but yeah.
Hamud will be hearing it, but okay, and then these other cases,
Mr. Emmons, I was told, Judge, that we're not sure about, he was checking to see if they were gonna charge them or not, and I see.
There hasn't been any charges authorized on those, so I'm not sure who's currently reviewed or if they're being reviewed, so I can take a look at those this week, hopefully.
All right. Adjourn this to September 3rd, 2025, 9 a.m.
Thank you, Your Honor.
All.
Your Honor.
Thank you. Thank you, Mr. Artuso.
Okay, thank you.
Oh, yeah. 3 charges, 2 different attorneys. Yeah, I don't know what it is, but it doesn't.
That's called the case of People versus Nicholas Stemmel.
And good morning, Your Honor. Rita Young, P44626, appearing on behalf of Mr. Nicholas Stemmel, who's also on Zoom. Sir, could you state your name for the judge, please?
Stemmel.
All right, very good. What are we doing?
Judge, we're asking for a final pretrial date. Try to see if we can resolve this matter.
You don't want to do this Friday. I'm taking it. I should set it this Friday. We haven't seen you in forever, Miss Young. Make you come down here. But I'll give you the October dates.
You're so kind.
Jury final settlement conference will be October
October 17th.
October 17th, 2025, 9 a.m. Jury selection, if necessary, will be October 20th, 2025 at 8:30. Both of those proceedings are in person.
Yeah, the guy here to the right, I've seen him before. I think I did a separate video of him because he kept working on his damn truck then as well. Let's see if I can find it. A couple of months ago, maybe. Let's see if I can find it. Might be. Let's see here. Dun, dun, dun. Or maybe it's on the other channel. Oh, let's keep playing while I.
Okay, thank you so
So
very much.
sorry.
Thank you. All right. Take care.
Likewise, Judge, can I hear who the prosecutor was? I didn't hear her name.
She doesn't have a name. No, I'm kidding. The prosecutor actually assigned to it is Miss Landy.
Okay, thank you so very much, Judge.
Thank you.
Mr. Stemo, you can zoom out now and I'll be in touch.
Okay, thank you. Court does call the case, People versus Abdallah Bader.
Christina Berger for the people. This is not a pretrial, not a felon.
And as per usual, prosecutors cannot work a microphone.
I already issued an order to show
Yeah, that guy
cause.
on the bottom right, I recognize him from maybe
Was it set aside?
2 or 3 months ago.
Pardon?
And they worked it then as well.
It had to be. Bench warrant will issue for the defendant's failure to appear in this matter. Bond will be set at 10,000.
Yeah,
10%.
that's someone who's going to show up in orange jumpsuit next
That
time.
warrant will issue immediately. There having been a previous warrant as well as show cause. Court does call the case of the People versus Christopher Banks.
Allie Zen on behalf of the people, Your Honor.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Banks, who stands to my right. Please state your name for the record, sir.
Christopher Banks.
Excuse me. Thank you, Your Honor. I'm respectfully requesting an adjournment. I did reach out to the people regarding this. We don't have any media discovery yet, and I believe it does exist based on police report references. So I'd be asking for one adjournment or another adjournment.
September 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continued. Court does call the case. People versus Alexis Berry.
Christina Berger for the people.
I don't remember.
Sorry, Your
what
Honor.
case he
Assistant
was
Public
on.
Defender Natalie Pate with and on behalf of Miss Berry, who is appearing via Zoom. Can you please state your name for the court?
Alexis Berry.
All right.
Thank you, Your Honor. I am requesting an adjournment in this case. Ms. Landy did make an offer before she went out to an operating while visibly impaired second, and I did discuss that with my client. There is some other mitigation information and things I'd like to discuss with Ms. Landy regarding this. To my understanding, my client is completely compliant on bond as well as her current probation. So I'd be asking for an adjournment into the September date.
September 17th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Ms. Berry. Thank you, Your Honor.
Thank you.
Thank you. Court calls case People versus Grace Bonilla.
People, Your Honor. Christina Raget, pretrial without counsel.
Bonilla, no response. I'll issue an order to show cause. Court calls case People versus Michael Bork.
Christina Berger for the people.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Burke, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Yes, Michael John Burke. Morning.
Good morning.
Thank you, Your Honor. I'm respectfully requesting an adjournment. Ms. Landy did indicate to me that there would be no offer in this case, and I do need to further discuss that with my client.
September 17th, 2025, 9 a.m. Bound continue.
Thank you. Thank you, Your Honor. Thank you, Mr. Burke.
Court calls case People versus Matthew Bullard.
Allie Zed on behalf of the people, Your Honor.
No, Zachary is not
Issue
in
an order to
server. He's
show
just
cause.
waiting for his case to come up. But I do recognize
Case
him
People
from
versus Zachary
a few minutes
Burlap.
ago.
Allie Zed on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burlett, who appears via Zoom. Sir, can you please state your name for the court?
Zachary Burlett.
Thank you, sir.
Thank you, Your Honor. I have discussed this case as well as the discovery with my client. We're asking for an adjournment so that I can speak about some mitigation information with Ms. Landy. This is an older retail fraud case from alleged incident date from over a year ago. Mr. Burlett's currently on probation to this court. He's doing very well in transitional housing, so I'm just hoping to talk to Ms. Landy
He's in
about.
transitional at this point.
He is through Dawn Farm, Your Honor.
So let me adjourn this out to September 17th, 2025. He's on probation. How long have you been on probation to me?
Since June 11th of 2024.
Okay. That's what I thought. I knew it had been a while. So I'll go up September 17th, 2025, 9 a.m. How are things going otherwise?
Everything is going great. This player has been very supportive. Still, being the surface in the community, still learning, just taking it day by day.
There you go. All right. Well, I won't tell Miss Polera that you said nice things, so. Okay. All right. Spurlett, you take care.
You too. Oh, wait, really quick. Do I have an upcoming review here soon?
On the other case?
Yes, I'm on a probation.
You'll have to contact probation. I don't have that information in front of me because I don't have that case in front of me.
I'll call her and tell her things and find out.
Okay, I'm gonna tell her you said bad things about her, but don't worry about it. I'm gonna get to her first. We'll see how that conversation goes then. All right. All right, Mr. Burlett, you take care.
Bye.
Thank you, Your Honor.
Court does call the case People versus Deaja McCoy.
Allie Zed on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Deaja McCoy. Respectfully, Your Honor, I did. You notice I tried to walk up slow.
Yes, I did. I did.
Oh,
They're gonna take all
there.
day. Okay? I'm like,
I was trying to buy myself 5-10 minutes. My client did say she was about 5 minutes out when I just stepped out.
how long ago was that?
About
Half an hour.
a minute and a half ago.
Oh, right.
No, right when I stepped out and came
You
back.
were in here a minute and she didn't tell you.
That's when I came. You see me go out and come in. I've been here about 72 seconds. Maybe
72
3 seconds or so. She did.
So she told you she'd be here in 5 minutes.
Yep, she said she was 5 minutes out.
Okay, was that a real 5 minutes or how soon are you gonna be here? Give me 5 minutes.
I know about 22 minutes ago she told me 20.
Okay.
But I heard her.
I'm done. Third, I'm done. I'm done. I'll pass it. We'll call it up at the beginning of the next block.
Okay, when's the next block start? Yeah.
Your client is not here,
Oh,
and
no.
now you're gonna like pressure me for when does it start?
I just wanted to know about
We're
time for breakfast.
inconveniencing your day?
No, I just wanted to know about time for breakfast. That's all.
Well, what kind of breakfast you gonna have?
McDonald's.
Go, because I've seen you when you don't eat, and it's gonna be a mess. All right.
All right. Thank you,
Okay,
man.
you'll have enough time.
Appreciate it.
If he goes to the McDonald's in Canton, I'm sending police. There are 2 McDonald's within like 3 minutes of here.
Left, right out here.
You can go left or right.
Okay. Okay. I'll go either one. Right?
Well, there are 3 right around here.
Gotcha.
Okay?
All right. No,
Don't get lost.
I won't.
Okay.
Thanks.
What are you gonna get?
Sausage, egg and cheese, combo, add biscuit, egg and cheese.
Wow. Okay, enjoy.
Oh, yeah, just like.
I want that too. So, that's a lot he's gonna eat. Gotta come back here napping. Have we been able to get through to Mohammed Day?
Not received a response from the NDOC.
Mohammed Day.
Yeah. If you respect Judge Simpson, if you especially can you make him laugh? But then again, his client better show up because he just put his ass on the line for his client. So, and I remember a month ago or something, one of the newer public defenders who moved in from New York said he's on his way. He's on a bus. Really? Yeah. It's a very slow bus. It's a slow bus. Oh, that was so funny.
And okay, counsel, on Deanne matter, what I'm gonna do is I'm just gonna adjourn this out to September 3rd.
May I make a request, Your Honor?
You're going to anyway, so yes, go ahead.
Could it be past that date? So I applied to visit him in Baraga.
Got it. You've got to get in. You've got to get, yeah. Will the 17th, you think, give you enough time? Probably not.
It might not be very frank, Your Honor. I'm not optimistic that would be enough time. It might be.
Why? They don't have you on the list?
No, I applied.
Because you're like suspicious, aren't you?
Maybe, if that's the thing.
That's why.
I was all ready to go in person to the UK at this point, but now he's not there, so. I apologize.
October 1st,
That'd be great. Thank you so much.
2025, 9 a.m.
Thank you.
Miss Perrine, nice of you to show up. I mean, good morning.
Good morning.
How are you doing?
I'm doing well, Judge. Thank you for asking. How are you?
I'm doing great. He said, what's his name to get breakfast? For what? He's not gonna bring enough for all of us.
What kind of breakfast?
Huh?
McDonald's. He's going to McDonald's.
He's going to McDonald's. We don't know which McDonald's he's going to.
Mr. Bird. That's a good McDonald's. It is. Mm-hmm.
As opposed to the bad McDonald's?
Okay, I live by a horrible McDonald's. Me too. Same here.
Okay, let's broadcast that to the world.
It's
All
It's like, it takes forever. They never have anything you want. This one's.
You seem a little bitter.
It's so close to my house. So easy to go get a Happy Meal for my child when he's.
Oh, now you're bringing the kids.
But I can't.
All right.
It's horrible. I avoid that McDonald's.
Okay. All right, I'm gonna stand in recess. You need to calm down in the interim.
Okay.
All right, and I'll come back and we'll start the next block. Court stands in recess.
All right.
Oh. All right, and
Whoa. Yeah,
and through the magic of recapping,
you may be seated.
that was a good session. Oh, yeah, folks, there are good judges out there. There are good judges out there. They are not all Canone. They're not all Judge Gull. There are good judges out there.
Court does call the case of the people versus Esther Faber.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Capper. Ms. Capper, please state your name for the record.
Esther Capper.
We're requesting an adjournment. I'm hoping to get some more mitigation information over to the people.
September 17, 2025, 9 a.m.
Thank you.
Thank you.
Thank you. Court calls the case of the people versus Alexis Brown.
Good morning, Assistant Public Defender Lauren Perry on behalf, well, not on behalf of Ms. Brown. We are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
Oh. Oh no. Oh no. We have a pro se, Folks, we have a pro se. Oh, no. Oh. All right, let's get to it.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So in this matter, Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washtenaw County, State of Michigan, that you did commit the offense of assault and or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor, punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation, in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mhm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you,
I served 30 days already.
and if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim as well.
And the monetary amount? 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
I
All right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
So
Okay.
what do you want this set for, ma'am?
I mean, Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. I guess.
You want a jury trial or a non-jury trial?
It doesn't really matter.
Well, you've got to make a decision, ma'am.
If it gotta go to trial, then it gotta go to trial.
Okay. Do you want a jury trial or not?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury, fine, that's fine with me.
Jury final settlement conference in this matter will be set for 17th, 2025 at 9 a.m. Jury selection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person.
Yep. September 17th.
So am I free to go? So why am I not free to go? If she just said she got a bond.
Pardon?
Why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post a bond.
Okay, what's the bond? Cause you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
Well, honestly, it went a lot smoother than other cases.
It's your fault, parenting. Your fault. You just like suckered me. into that. You got up there and then just said, well, we're the attorney of record, but
We're starting off the morning with a series of bad decisions already. This is wonderful.
yeah, I know, but they're all by Kearney. The whole McDonald's thing and then this. And
Oh,
okay, let's try this one. Court calls the case People versus Deja McCoy. Is she here? Oh,
Brandon Center, Your Honor. Actually, she was here when I was walking out, Your Honor.
how come you didn't come back? You guys got to switch that.
Sorry about
How come you didn't come back?
I came back, but you was gone. I figured you
I have
left the
been
bench.
here.
I
Don't
figured,
say
I figured you left the bench. I
Why
figured
didn't you
left
come
the
back?
bench.
The client was here.
When I was
And the
going
things
out,
he was saying about you, I was defending you. I want you to
I was
okay.
dismiss.
He was, I think, making okay. Reality is, I think you were making your decision because you wanted McDonald's. And you kept saying she wasn't here. That's why you didn't come back down the hallway. Isn't that right, Bert?
No, that's no, I'm talking about when I was walking outside. We crossed each other's path.
Outside, you weren't going to turn around.
Oh no, I wouldn't have did
Because
nothing like
you had
that.
McDonald's on your mind.
I would have got Coney. I had Coney on my mind. Didn't have time for it. But yes, Your Honor, Brandon Bird on behalf of Deasia Yargi McCoy. Ms. McCoy, can you please state your full name for the record?
Deasia Nicole McCoy Yargi.
Thank you. All right, what are we doing?
Respectfully, Your Honor, we just asked for adjournment to give me some time to talk about the offer with my client and to go over these videos with her.
Okay. September 3rd. Have enough time, sir?
Actually, I'm started trial on September 2nd, Your Honor, and I'm not sure if it'll be done on the 3rd.
Yeah, like you. September 17th, 2025. 9 a.m.
Thank you, Your Honor.
Thank you. Have a good day.
Have a good day.
Okay. Did you get your food?
I did.
Okay, all right.
oh.
Court does call the cases of the People versus Jay Dingman.
Conrad Siller on behalf of Pittsfield Township.
Oh, the township issue.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Dingman. Mr. Dingman, please state your name for the record.
Jehoan Dingman. Thank you.
Your Honor, unfortunately, I did not have a chance to speak with Mr. Dingman. I was calling him, but however, he's in custody.
Yes.
Obviously. I believe he's being held on a felony case that is before Your Honor. I do not remember the next date. I would ask for the next possible date so I can have a full conversation with Mr. Dingman about what's going on these cases and how we can resolve them.
He's up tomorrow. Okay. And what I'll do is I'll adjourn all these to September 3rd, my next day, 2025, 9 a.m.
Thank you.
Well, I'll see him tomorrow.
And I apologize, Mr. Dingman, for not speaking with you.
Thank you. Thank you, sir. Court calls case People versus Renee Darga.
And then on behalf of the people, Your Honor. Your Honor,
I'll issue an order to show cause for the defendant's failure to appear.
Okay, failure to appear.
Calls case People versus Alonzo Doss.
and then on behalf of the people, Your Honor.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Doss, who should be present via Zoom.
Hello,
Mr. Doss. All right. Do you have a camera?
Yep, trying to cut it on. Yes, sir. Sorry about that.
Oh, there he is. Okay. What are we doing?
Thank you, Your Honor. Your Honor should be in receipt of a plea form and police report. There is a resolution in this case to which my client would be pleading no contest to an added count 2 of retail fraud in the 3rd degree, and in exchange count 1 of retail fraud in the 2nd degree would be dismissed.
Okay, that's the court's full understanding of the agreement. Is that correct?
That's correct, Your Honor.
All right. Sir, please raise your right hand. You need to be someplace stationary.
Okay.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
Alonzo Doss.
All right. You can put your hand down. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud third degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right, 2 things about it. I have to make sure that you understand. The first thing you need to understand is it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
Basis for no contest plea.
Potential civil liability, Your Honor.
All right. So, sir, to the charge of retail fraud third degree, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, sir.
Under paragraph 5, those are your rights that are part of a trial. You understand you're giving up those rights as well as all the rights that are contained on that form.
Correct. Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Correct. Yes.
Your own free will?
Yes.
Court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 24-19959. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, or not counsel, but sir, I need you to understand that if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea. And you would also, the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Can you elaborate a little bit on that, Your Honor?
All right. Under the Michigan court rules, there are certain things that are misconduct. Say, for example, violation of your bond conditions, right?
Okay.
If you do that between now or between the time that I accept the plea and your time of sentencing, if there's some type of misconduct committed by you, commission of another offense, those kinds of things, then what would end up happening, sir, is that the court would no longer be bound by any sentence evaluation. There really isn't one in this case, but also you would not be entitled to withdraw your plea.
Okay, so I'm sure other than breaking the regular laws and something along these lines that got me here, outside of that, is there anything else?
Mr. Doss, it's pretty much if you continue your compliance on bond and you don't commit any alleged offenses, that should not come into play. But in this case, you don't have a sentence agreement anyway.
Okay, like basically what I'm getting to, if y'all don't understand, is like when you're on probation or parole, you have certain stipulations that you can't, or on bond. I was trying to make sure that there wasn't any specific, like other than me not stepping foot in that location. Is there anything else that I should be aware of?
Nothing new or additional since we last spoke, Mr. Doss.
Okay.
That
Okay, do you understand what I just
highly
told you?
suspicious.
Yes, Your Honor.
That sounds like he's okay. Please tell me what I can do. No, the courts will tell you you can't do these things. So he's looking for approval, or what he thinks is approval of something. Polly, hey, tuber called Samantha Benigno did an analysis on Zach Anderson. I haven't seen that one. The I don't belong here. All right. I will check it. I will check it out. I will check it out. Thank you for the tip.
Counsel, are you aware of any other promises, threats, or other inducements related to this plea?
No, Your Honor.
Not that I'm aware of, Your Honor.
Has the court complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's plea to count 2, the retail fraud 3rd degree. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
August 27th at 12 noon.
August 27th, 2025, 12 noon. All right, sir, you need to hang on the line. I have probation intake on the screen. We're going to put you into a breakout room so we can get the process started, okay?
Yes, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, Mr. Doss.
Court does call the case. People versus Gibson. Deon Gibson.
Assistant Public Defender Natalie Tate with and on behalf of Mr. Gibson, who is approaching. Please state your name for the record, sir.
Deon Gibson.
I have before me a plea form that indicates that the defendant would be pleading no contest to the charge of assault and or assault and battery. The 93-day offense. Upon the successful plea to that charge, count 1 would be dismissed. That's the court's understanding of vigor.
That's correct, Your Honor.
That is correct, Your Honor.
All right. May I have him sworn, please?
Yeah. Some swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so we got.
Yes.
Lloyd Newman, please spell your name.
Deon Gibson, DEVON-GIBSON.
All right. Mr. Gibson, this is court's understanding that you're going to plead no contest to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about it I have to make sure. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Still wish to plead no contest?
Yes, sir.
Basis for no contest plea?
Potential civil liability, Your Honor.
And sir, to that charge, how do you plead?
No contest.
You understand? That's all right. You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form. Is that correct?
Yes, sir.
Any question about any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Mm-hmm.
Yes?
Yes, sir.
All right. Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 2529070. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense.
Hi, Wendy. Yeah. Have you hit the like button? Have you check if you're still subscribed?
Counsel, are you, sir, I do have to advise you that if you commit misconduct between today's date and the time of your sentencing, as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and you would also not receive the benefit of any sentence. The court would not be bound by any sentence recommendation or evaluation. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
August 27th at 12 noon.
August 27, 2025, 12 noon. All right. Probation will be down to see you and try to get everything all set. All right, sir?
Okay, thank you.
Thank you, Your Honor.
Bond continue. Court does call the case, the people versus Julia Martinez.
Conrad Solar on behalf of Pittsfield Township.
You have to start there. They're not. All right, hold on that one. The court does call the case, people versus Carlisle Travis.
Allie Zend on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate for Mr. Travis. Your Honor, I do not have an explanation for his failure to appear. I did not have a phone number that was working for him. Unfortunately, he did not respond to an email that was sent by our office. I would respectfully request an adjournment for the record. I don't have any other further explanation.
Bench warrant 5,000. Give a 10% privilege. I'll have those warrants issue immediately. Well, I'm not gonna have it issue immediately. I'm gonna give. What is 1 week out, the 13th?
The 13th.
I won't have those warrants because of the absolute screw up regarding the JAS issue and you contacting your client. I won't have those warrants issue until August 13th.
Thank you, Your Honor.
Call the case, people versus Devon Julia Martinez.
Conrad Solar on behalf of Pittsfield Township.
An Assistant Public Defender Natalie Pate with and on behalf of Ms. Martinez. Please state your name for the record.
Seven Julia.
Hi. Thank you, Your Honor. I'm respectfully requesting both an adjournment and if the court would consider a possible release to treatment for Ms. Martinez. I can provide Your Honor with an order. It is my understanding she is still being held on her felony matters, but she is hopeful that she can get a release to treatment on those cases as well. So I'm making that request on her behalf as well as asking for an adjournment.
Excuse me, I was going to keep the $500.
I'll adjourn this to September 3rd, 2025, 9 a.m. And any objection from the people about release to treatment?
No, Your Honor.
Then if you submit an order to the court, I will sign that order.
Thank you, Your Honor. And my client is asking for clarification. Is her bond currently $500? However, she would not have to pay that to be released to treatment, correct?
Correct. I would release her to PR on a I would release her on a PR to go to treatment.
But $500 still exists.
But if she doesn't complete treatment, and we've been down that path before, she comes back.
Understood, Your Honor. So,
but there is still
the judge just gave you a PR to be released to treatment.
But does the $500 bond still exist? Is it there? So is it also? Yes.
If that is what your bond is currently a PR to treatment, but you would be still getting credit for your time in custody.
Okay, can we keep the $500 bond as well?
Well, it'd be a $500 bond until they find treatment, then it will transform into a PR so you can be released to treatment.
Okay, so, but it still is a $500 bond if
right now, yes.
Right.
Okay, thank you.
Yes,
Thank
but this
you.
will not hold you up from going to treatment.
Okay, thank you. So can I?
Thank you, Your Honor.
Let me step back.
You gotta keep going. Gotta keep moving. Apparently, that's your fault too. Court calls the case, people versus Paris Lester.
Conrad Solar on behalf of Pittsfield Township.
Allen, and on behalf of the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Lester. I did provide the Zoom information to Mr. Lester. I did not have contact with him. As of Friday, we knew he was in the hospital. But as of now, I do not know where he is.
There's Lester. Being no response, a bench warrant will issue for defendant's failure to appear. Again, because of the mess up with JIS and the information, I'll set bond at $5,000. I'll give a 10% privilege. However, that warrant will not issue until August 13th, 2025. See if you can locate your client since they cut off access to your information.
Okay.
Oh, by the way, so that we're also aware, whatever this, trying to be nice about it, try not to use bad words. This whole thing regarding JIS, there's also now a hiccup with community corrections because they no longer have access.
Oh,
Judge, I can't handle any more hiccups this week.
Of course, because as Perry often thinks, it's all about me.
So Your Honor, if I was gonna contact SCAO to see if I could get JIS access, that probably wouldn't be a good idea right now.
Oh, you can absolutely contact them, but if you get access, they apparently just give it random to whomever and then take it away. I don't know what they're doing, but I don't know. I mentioned that only because I'm not sure.
yeah, it's not the first time this court have had problems with access to different systems. To my understanding, it was a low-ass bidder who won the contract. But I mean, what we see here is still a lot better than many other courts.
What hiccup that may cause with the orders, like the last block, I had a number of those SoberLink orders, but I don't know that they can complete it without some additional information. So we're trying to fill the gap because we don't have enough to do. And God forbid they be able to find a date of birth on a computer, right? Okay, I'm done for now. I'll come back to it. Court does call the case, People versus Anthony Miller. It's the stupidest thing in the world. Information is
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Miller. Good morning, Ms. Miller. State your name, please.
Anthony Lavelle Miller.
Thank you.
Your Honor, two things regarding the pretrial. I'd asked for an adjournment. Mr. Miller would like to do some additional investigation,
Okay.
and he would like me to address his bond.
Okay. Why don't you, how much time will it take you to do can you do that by the 3rd?
I think so, Your Honor.
All right.
Thank you.
So I'll adjourn the pretrial to September 3rd, 2025, 9 a.m.
Regarding his bond, he just saw, Your Honor, on Thursday on a felony. You did modify his bond to a personal bond because the public defender that represented him then provided, Your Honor, with proof of incarceration. That is why he missed his felony PCC. He has $100 bond on this case. We're asking for a personal bond to be released on this one. I have the proof of incarceration as again, that was provided.
Where's he gonna go? If I
The line center.
When his pretrial that he missed on this file was the 18th, he was incarcerated at the Wayne County Jail, according to the sheriff there, on September 17th of last year. So again, he's asking for a personal bond. I did get a good phone number for Mr. Miller. He does have a phone, so if and when he's released.
No, you keep going. I've already made my decision, but go ahead.
Well, we'll communicate.
I hear you talk. Go ahead.
That's all I have to say.
That's all you have to say? Okay.
That's it.
Bond is reduced to a personal recognizance, $5,000.
Thank you, Your Honor.
Oh,
Thank you.
all right.
Great day.
You do the same. Make sure you come back. Court call. Yeah, make friends.
He's happy.
Is he?
Yeah.
It must have been something you did. Court calls the case People versus Tierra Peterson. Then I'm down to, that's my last one.
And then on behalf of the people,
Conrad Seller on behalf of Pittsfield Township.
And Assistant Public Defender Natalie Pate for Miss Peterson, who I hope is present via Zoom.
Tierra Peterson,
All right, let's see what this case is all about.
you think she's the murderer? Tierra Peterson?
Hello.
Hello, what's your name?
Hello. Kurt Bushline. I'm
Okay, that's
new to
not-
this, Your Honor. I'm trying to figure this out.
Okay, no, you're good, but I didn't call your case.
Okay, I can't see you. That's why I was trying to figure this out.
You can't see me? Yeah,
Yes,
that's
sir.
not a great loss.
Okay, I'm sorry.
All right, so just hold on. We'll get to your case at some point, I'm sure.
Okay, all right. I'm
When is
sorry.
he set for? What's your name again?
Kurt James Bushline, Buschlein.
Sam?
Kurt, Kurt.
That's a guy who left.
Are you sure you're supposed to be before me?
Yeah, 10 o'clock. I'm supposed to be there at 10 o'clock.
Okay, you gotta be before Magistrate Odetella.
Okay, well, it said you, sir, on the paperwork, so I don't know. So
Yeah,
how do
I
I
know.
do this then? How do I do this?
All right, so we'll get. Yeah, you need to call our clerk's office so they can give you the Zoom information, okay?
Okay, yes, sir. So we'll go off this and call the clerk's office.
Yeah, you want the phone number?
Yes, what is it? 973-4545?
Absolutely.
Okay, sir. Thank you and have a blessed day.
Thank you. You too. Okay, now back on Tierra Peterson.
So, Your Honor, I left a voicemail at one of the numbers I had for her. She did appear via Zoom for the last hearing. However, she didn't return my call, and then an alternate number I had for her was now disconnected. I have not had a conversation with her since the last hearing. I don't have an explanation for her failure to appear, I guess is the bottom line, but I'm respectfully requesting an adjournment.
Bench warrant, 5,000, give 10% privilege. Warrant will not issue until August 13th, 2025, JIS.
Thank you, Your Honor.
thank you, Your Honor.
Court does call the case People versus Kerry Wynn.
Conrad
And then
Seller.
on behalf of the people,
Oh, just, yes, state please. Okay, thank you.
Kyle Burrell on behalf of Mr. Nguyen. Mr. Nguyen, please introduce yourself to the court.
Kerry Wynn. What are we doing?
Your Honor, at this time, if people are unable to proceed on this case, I would ask for a dismissal.
Of course, without objection from defense.
All right, this case is dismissed.
Thank you, Judge.
All right.
Well done.
Yeah, off you go. Congratulations. Off the jumpsuit into ordinary clothes and out the door. All right.
Court calls case People versus Sean Charley.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Charley. Take your name for the record, please, sir.
Sean Arthur Charley.
Your Honor, we have come to a resolution. I did provide a plea form and an advice of rights form, but I also have hard copies for the court if needed.
I have.
Great. So the agreement is that he'll be pleading guilty to an added count of retail fraud third with also with a further agreement to pay full restitution.
Right. That's the court's full understanding of the agreement. May I have him sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so you got?
Do.
Lower your hands, state, and then spell your name.
Sean Charley, SeanCharnley.
Mr. Charley, it's this court's understanding that you're going to plead guilty to the charge of retail fraud third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost.
Yeah,
Fine could be increased
shoplifting
if the
or
property
minor
taken. If
theft.
that's greater than $500, that would become the maximum fine. You understand that?
I do.
Probably pled
Joe
down
plead
from
guilty?
theft
I
to
do.
retail
To that
fraud.
charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I have.
Any question regarding any of those rights?
None.
Look at paragraph 5, you'll see a copy on the podium.
I do.
Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
Nothing.
Anybody threaten you or coerce you?
Not at all.
You're doing this voluntarily
I am.
of your own free will
Absolutely.
because you believe that you're guilty?
I am.
May 14, 2024, at the location of 7000 East Michigan Avenue, that being the Walmart, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
I took items that didn't belong to me and didn't pay for them.
And tried to walk out of the store?
I did walk out of the store.
You walked out of the store with them. Okay. Store was open to the public at the time?
It was.
You didn't have anybody's permission to take that property?
I did not.
And this property you took was offered for sale by Walmart?
Yes, it was.
All right, counsel, have I complied with the court? Well, before we get to that. Sir, I do have to advise you, if you commit misconduct as defined by the Michigan court rules between the time of this date and the time of your sentencing, your plea and your sentencing, you would not be entitled to withdraw your plea, and you would also not be entitled, or the court would not be bound by any sentence recommendation. You understand that?
Yes, I do.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred.
Your Honor, I did want to address that.
Okay.
He does have 138 days credit in the Washtenaw County Jail. I would ask for immediate sentencing, if the court is amenable to that.
You have an agreement regarding restitution. So somewhere along the lines that has to be figured out.
I did want to also put on the record the amount for the police court is $368. So that's the amount that I reviewed with Mr. Charley and he's agreed to pay. I don't know if Ms. Sister counsel.
Is this the only thing holding him?
No, Your Honor.
So he's gonna be in it anyway?
Yes.
Okay, then. So if I release him on this, he's not going anywhere.
No, no.
Are we done?
Yes, Your Honor.
Okay, good. I'm gonna refer him to probation for pre-sentence investigation and report, as well as determination for sure of the restitution involved. Sentencing will be
August 27th at 12 noon.
August 20.
Yeah, I'm not sure what they are doing in California. I mean, $1,000? I mean, if somebody shoplifts for $1,000, let's say a mom and pop store, convenience store or something like that, $1,000 in shoplifting, that's a good chunk of their profits. And if they don't even prosecute, how are they supposed to get their money back?
2025, 12 noon. All right.
Thank you.
Thank you. Yeah.
Okay.
That's the limit. Okay. Then I'll call him. Court does call the case People versus Michelle Campbell.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Campbell. I'm sorry.
Okay.
Michelle Campbell.
And Alexander, on behalf of the people, Your Honor.
And so that you know, I've slipped into the 11 o'clock block to balance against. That's why you're not seeing it.
Your Honor, I did attempt to make contact with Ms. Eckle. However, we don't have any good contact information for her, so I was unable to actually make contact with her. For the record, I'd ask for an adjournment.
Bench warrant 5,000 10%, that warrant will not issue until the 13th of August.
Another one.
Does call the case, People versus Ashley Fix.
Conrad Solar on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Fix, please state your name for the record. Ashley Ann Fix. Thank you, Your Honor. I believe we are very close to a resolution of this case. I have gotten Ms. Fix to sign the release of information for me to get her CMH records so that I can provide them to the prosecution to resolve this case. I'd be asking for one last brief adjournment.
The next date is September 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Continue. Thank you. Court does call the case, People versus DeMar Ficklin.
Christina, they're hearing for the people.
DeMar Ficklin.
Yep. Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Ficklin.
Can you state your name, please, sir?
Yep, DeMar Ficklin.
Okay. I need a camera, please. What are we doing?
Sorry about that.
Your Honor, we have come to a resolution.
Yes.
Provide a plea form. Mr. Ficklin is going to be pleading as charged under HIDA.
All right. Okay, sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name again for the record.
DeMar Ficklin.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of embezzlement by an agent or trustee less than $200. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
You understand that the fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine.
Yes.
All right. And understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
So my plea would be so while I was working at
Hold on. How do you plead? You pleading not guilty, guilty?
No contest.
Mr. Ficklin, if you want to plead no contest, we have to do some more paperwork, so we won't be able to do that today.
Okay, no, we can go with the guilty. I'm sorry. Yeah, we're going with the guilty.
Okay, so the judge will ask you for a factual basis in a little bit. We'll get into that, but for now, just answer the question he's asking. So do you plead guilty or not guilty?
We plead guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
You signed an advice of rights form with permission. Is that correct?
Yes.
Do you have any questions regarding any of those rights?
No, sir.
You understand that you're giving up all of those rights, including the rights contained in paragraph 5, which are your trial rights?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
Between the dates of October 4th, 2024 and October 18th, 2024, location of 3825 Carpenter Road, were you an employee at Meyer?
Yes.
And during that period in time, what did you do that makes you think that you're guilty of this offense?
Well, when I was there, I did grab a few paper plates, maybe a pizza, and a soda, and I guess took it to our back area where we store our stuff and bring it out to our customers, the department I work in, and so yeah, that's it. I
So
guess.
you took things from the store, took them to a back area, and then you ate them?
No, took them through the back area. Yeah, like the back door area. There's like to get out the store. Yeah.
Okay, what'd you do with the stuff that you took?
Oh, well, it was really family things really that feed my little brother, my sister.
Okay. So you took them out and used them for your own personal use?
Yeah.
Yes? Okay.
So
and you came into possession of that by the fact that you were an employee at mine.
So you took stuff and gave to your family because they were hungry. Why didn't you just ask? Hey, store owner, do you mind? These are close to expiration date. Would you mind if I got them for a reduced price? There are food banks. Why risk your job for a couple of pizza and paper plates? Why didn't you just talk to your employer? And instead, you're here, and now with a record. Now, I don't know the facts of the case. Maybe he did ask his employer, and the employer was a prick, but you still just can't take stuff and take it out of the store. Oh. One bad decision. Oh, mayor is a corporation. Okay. Yeah. These things happen over here as well. Then the union gets involved and we negotiate, and sometimes we do it successfully. Sometimes we can't. But then it's a civil matter, and often it just ends in no longer employed.
Yes.
You didn't have anybody's permission to take that property, did you?
No.
All right. I think we've got it, counsel, because I don't think I need a dollar amount. Sir, I do have to advise you that if I accept your plea and you commit misconduct as defined by the Michigan court rules between the time of this plea and the time of your sentencing, you would not be entitled to withdraw your plea, and you would not be, the court would not be bound by any sentence recommendation. You understand that, sir?
Yes.
All right. Counsel, is counsel aware
This
of
is
any
a bit
other
heartbreaking, actually.
promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of guilty to count one.
Yeah. This is a case that I handled, as you might know. Well, if you don't, I only talk about cases I'm involved with if it's more than 10 years and if it happened more than once. And this is sadly a reoccurring event on one of the not stores, but businesses where I have to go once in a while, because over there they handle some health produce. Sometimes health produce comes back from the stores, and then because it's close to expiration date, they have it on shelves for the employees to pick themselves, because otherwise it's just waste. Once in a while, an employee thinks, well, if I can take from that shelf, I can take from those shelves as well. No, you can't. No, you can't. Sometimes it's resolved with, well, now you know, pay for it, and now you know because they are otherwise a good employee, just a bit stupid. Other times, they don't really get it. Why? We can't take stuff from that shelf, not the rest of them, and they just don't get it. And I have to go back there a couple of times a year, and I've been doing that for the past 15 years. What to do? What to do? All right, back to this.
Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
August 27th at 12 noon.
August 27, 2025, 12 noon. And sir, I want you to wait on the line. I'm going to put you into a breakout room with my probation department so we can start that process.
All right.
Okay? Thank you.
Thank you.
Where have you been? Court does call the case of the people versus Matthew Fonseca.
Conrad Solar on behalf of Pittsfield Township.
Nesca.
On behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Fonseca. Mr. Fonseca, please state your name for the record.
Matthew Fonseca.
Your Honor, we are asking for another adjournment on this case, or this case is Mr. Fonseca has pending felonies. There was another one that was recently arraigned on. We're trying to get a global resolution. I believe they're all before Your Honor still.
Okay. When's he next up before me on that docket? Do you know?
The 14th.
I'm not too sure.
14th, maybe?
Sounds right.
I think it's the 14th.
Okay. I'll adjourn these to September 3rd, 2025, 9 a.m. That's my next date. Okay?
Thank you.
Bond continue.
There ain't no new family, is there?
What?
There ain't no new family.
Oh, the one you already read.
Court calls the case of the people versus Brian Foley. You don't have to close those out?
And this is on behalf of the people, Your Honor.
Pardon?
I have this listed as no counsel, I believe Mr. Foley.
He's here.
Yes, gentleman in the back.
Mr. Foley?
Have you not like this?
Just stick around. Okay. On me, yes, Your Honor. All right.
Yeah.
State your name.
Brian Foley.
All right. Mr. Foley, you're not represented by an attorney, right?
Right.
Oh, pro se.
All right. What are we doing on your case?
I had a unpaid traffic ticket, which I have since paid. I'm out of your courtroom.
Okay, hold on. You're here on a DWLS, a driver license suspended, and I see what you're saying. So what you're telling me today is that your license is now valid.
Correct, Your Honor.
All right. I can verify that his license is valid.
Then the people move to dismiss, Your Honor.
He did that all on his own? He didn't want an attorney and he got his case dismissed? Get Mr. Foley out. All right. Yeah, I'm sure you don't have any objection to the dismissal.
I don't, Your Honor.
All right, this case is dismissed.
Yeah, I know not to come before you unprepared.
Is that right? All right, Mr. Foley. Got it? Okay.
Up.
Foley, you take care of yourself, sir.
Your Honor.
Yeah, you
Court
learn
does
a
call the
lot
case, people versus Daryl Frederick.
by watching Judge
Conrad
Simpson.
Solar on behalf of Pittsfield Township.
Okay, more Pittsfield Township.
The Assistant Public Defender Natalie Pate with and on behalf of Mr. Frederick, who stands to my right. Please state your name for the record, sir.
Daryl Frederick. All right, what are we doing?
Thank you, Your Honor. There is a resolution in this matter to which my client will be accepting responsibility to double parking, and in exchange, the misdemeanor charge would be dismissed.
That is correct, Your Honor. So I move that count 2 of double parking. If you accept that admission, move to dismiss the original charge.
He was in jail for double parking. That sounds a bit harsh.
You admit responsibility to the fact that you double parked a motor vehicle on or about May 30th, 2025 in Pittsfield Township?
That is correct, Your Honor.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. I'll make that due 90 days after release. All right.
Thank you, Your Honor.
Thank you. Thank you. You were down there. We were looking all around for you. We thought we lost you. Court calls the case People versus Chad Jones.
Conrad Solar on behalf of Pittsfield Township.
And Aaron Zen on behalf of the people, Your Honor.
See what we're doing.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Jones. Jones, please state your name for the record.
Chad Jones. All right, what are we doing?
Your Honor, we are requesting adjournments on these as well. Mr. Jones has felonies that are currently pending, as well as we are hoping that he will be released to treatment relatively soon here. I did get information from Patrick at the jail that he's hopefully set to be released relatively soon, and I think that will help resolve what he's got going on.
And we signed the necessary orders on these cases.
Yes.
For that, okay. Okay, I'll adjourn it then to September 3rd, 2025, 9 a.m.
Thank you.
All right, thank you, Mr. Jones. So you can look this thing. Court calls the case People versus Jessica Fox.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Fox.
Where's Miss
Your Honor, I
Fox?
did attempt to make contact with Ms. Fox. I was not successful. I'm not sure if she's on the Zoom. She is.
Yeah, I'm here.
Yeah. All right, I need a camera, Miss Fox.
Yeah, I don't know why. There it goes.
Okay.
Okay.
There we go. Okay, what are we doing?
You know, there are ongoing plea negotiations going on. I'm asking for an adjournment so I can have another conversation with Ms. Fox. We weren't able to have one prior to today.
All right. September 17th, 2025, 9 a.m.
Yeah, one thing I want to talk to you about is you see that there are more or less 2 public defenders plus a couple that goes in and out that are handling all these cases. Public defenders' offices all around the United States are severely understaffed and underfunded. And this is a good court. Now imagine a bad court. Imagine Judge Gull, Judge Bev, or someone like those with only 2 public defenders for this entire docket. So I understand the strike that has been going on in, is it Georgia? They want to be paid more. And that's not even the public defender's office. Those are the people they hire outside of the public defender's office. And we saw that through the YSL trial. That, who was it, the one remaining, I forgot her name. I forgot her name. She was paid $5,000 a month. Now, that's not chump change. But she defended one person for 2.5 years for $5,000 a month. In that $5,000 a month, she had to pay for the paperwork. Travel, expenses, her own office, and everything. She nearly got bankrupt. Or was it Norfolk, Massachusetts? Oh, was it Norfolk, Mass? Okay. Thank you. Yeah, $5,000 a month. Yeah, yeah, that's probably Norfolk, Mass. Yeah, thank you. Yeah, $5,000 a month. I mean, that's, what is it, 60 grand a year for defending a client in the largest RICO trial in Georgia's history. It should tell everybody involved that, nah, that's not enough. And then you have Bonnie Willis, who gives herself $250,000 a year, and then does her speaking things and her galas and stuff. The 5 years Bonnie Willis have been in office, she has gone from basically broke to, I think she owns property, real estate, in excess of $6 million. You tell me how you can remain ethical with speaking fees and galas. I mean, she is going to be wealthy when this 4-year period is over. And they still voted her back.
Okay, thank you.
Thank you. Court calls case People versus Micah Jones.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Jones. Mr. Jones, please state your name for the record.
Micah Jones. Hey, what are we doing?
Your Honor, I guess we don't have an agreement on this charge, but Mr. Jones is going to be pleading guilty as charged to the retail fraud third. From my understanding, in my math, is maxed out on this charge. I do have a signed plea form and an advice of rights form as well.
Okay. And do we know if there's any restitution?
I don't believe so. I think everything was recovered.
Okay, well, they looked that up. Can I have them sworn?
Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Lower than spell your name.
My name, MICAHJONES.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud to third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes.
You understand you're giving up your right to appeal over it.
Yes.
Are you on probation or parole?
Yes.
You are?
On probation.
All right. Were you on probation at the time of this offense?
I believe so.
All right. I do have to advise you, this could be considered a violation of that probation.
Yeah. Judge Washington said something about it.
Pardon?
Judge Washington, she said something about it.
Okay. You understand that if it is considered a violation of that probation, you could be sentenced to the maximum allowable under that other charge. And understanding that, you still wish to plead guilty to this charge?
Yes.
Anybody promise you anything other than what's been stated here today on the record?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Yes.
Because you believe that you are indeed guilty?
Yes.
All right. Let's see. July 2nd, 2024, it's location of 3825 Carpenter Road, that being the Meyer, Pittsfield Township, Washtenaw County, State of Michigan. What did you do on that date that makes you think that you're guilty?
I did retail fraud.
The retail fraud. Okay. You went into Meyer.
One of Myers, I stole a few items.
And you took some items.
Yes.
All right. You tried to walk out without paying for them?
Yes.
All right. Store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No.
And these items that you took were offered for sale by Meyer?
Yes.
All right, sir, if I do accept your plea, I do have to advise you that between your plea and the time of sentencing, if you commit misconduct that's defined in the Michigan court rules, you would not be entitled to withdraw your plea, and also you would not be entitled, since there is none, to any sentence recommendation or evaluation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes.
Court will accept the defendant's plea of guilty to this charge.
All right. This day is more of the same. Now, early on, I heard from you guys in the chat that the day after this, a lot of interesting stuff happened. So, let's go to the next day here. No, what was it? The 9th or the 8th? Oh, I don't remember. Because this was the 6th, and the day after would be the 7th. That's the PCC docket. Or are we talking about the 8th, which is final settlement and preliminary examination? Let's go for the final settlement conference and see if that brings us anything fun. Dun, dun, dun. Ta-da.
We're all set. Could I have the waiver, please?
Your Honor, Alexander, on behalf of the people, Your Honor, the people would waive any potential conflict between this honorable court and the Office of the Public Defender. While the people don't believe such a conflict exists, the people make this waiver in avoidance of.
Good morning, Assistant Public Defender Lauren Perry. The Public Defender's Office likewise does not believe a conflict exists, but if not, to be also waived.
All right, the court for its part does not believe there's a conflict either of the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Roman Hop.
Alexander, on behalf of the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Hop. Mr. Hop, state your name for the record, please.
You, Hop.
Your Honor, can you briefly approach?
Yes, you may.
Yeah, he didn't seem too well.
Okay, go ahead.
Your Honor, today's date and time set for final settlement conference. At this time, I'm going to be asking for an adjournment. New updates to this case have come out, and at this point, the defendant is in custody for failing to appear at a PTO violation here up in circuit court. There's also a new case that will be upcoming and will be charged today for an FA that occurred on July 26th. So in this case, I'll be asking for an adjournment to the October dates, as well as the defendant's bond being denied in this case for the bond violation that is upcoming for the FA.
Your Honor, no objection to the adjournment to the October final settlement conference date. Regarding bond, I'd ask that the court keep his bond as it is. As the court knows, this case hasn't been charged out yet. He hasn't been arraigned on it. If he's going to be held on that case, a magistrate will make that decision when he is arraigned.
What I will do is I will adjourn the jury final settlement conference and jury selection to October 17th, 2025, 9 a.m. for the settlement conference, and jury selection, if necessary, October 20th, 2025 at 8:30. Given the circumstances, what I will do at this point is I will revoke the defendant's bond. And that's based upon the representation pending a hearing on the violation. If you'd like me to set that, then you just let the court know. We will set a violation. Okay, all right. So ideally, the best thing, set it after the arraignment. Sure. All right. They bring me. They're ready for the next one. Okay, court does call the case of people versus DeJure Bond Sanders.
Allie Zed on behalf of the people, Your Honor.
They weren't ready.
How's it going,
I
Judge?
just want, I want Bird and Matt to wait. Bond Sanders. I'm just letting you know how I feel.
Good morning, Public Defender Lauren Perny on behalf of Mr. Bond Sanders. State your name for the record, please.
DeJure Bond Sanders.
Your Honor, we have come to a resolution. Mr. Bond Sanders is going to plead as charged in this case. This was part of a global resolution that included some felony charges that were up 2 weeks ago at exam. Those felony charges were dismissed and he pled it on a DB there.
And that's correct, Your Honor. That file is coming before Your Honor. I believe that sentencing was adjourned. After the plea in this case, though, Your Honor, the victim is here to request contact. I'm not sure if the court will on the other file, it's still no contact as well. I'm not sure if the court has that file.
I do not have that file with me. Sorry.
Yeah, scheduled for the 18th. Did you say that? Sorry. The sentencing on the first DV is scheduled for the 18th. I assume Ms. Pilara is going to.
I'm going to let her take a look at all of that before I make a ruling on contact on this, just to let you know. I want to see my phone. All right.
Your Honor, sorry, before we enter the plea, Mr. Bond Sanders is asking if you'd consider entering his, or giving him back his phone privileges. They were revoked. I couldn't give you a date, but several weeks ago, given the representations made by the people.
That's right.
Hey, Dave, this is in your neck of the wood.
That's why they were revoked.
Correct. And which was a violation of his bond. I am not inclined to reinstate those phone privileges at this point. Given that everything is coming up, I will take a look at everything come the 18th. Fine. But may I have him sworn?
Raise your right hand. Do you solemnly swear
You were
or
there
affirm
last
the
week.
testimony you're about to give be the truth, the whole truth, and nothing but the truth, so you got? Lower, then say your name again.
Were you in Washtenaw last week? Were you in Judge Simpson's court? Or some other court? Were you on camera, Dave? If you were, we need to find that.
DeJure Bond Sanders.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You
Oh
understand
yeah,
that? Yes.
Judge Simpson was on vacation.
So was to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of June 27, 2025, at the location of 2265 Glencoe Hills Drive, Apartment 5, Pittsfield Township, Washtenaw County, State of Michigan, what did you do regarding, is it Natasha Henderson that makes you think that you're guilty?
I threw sand at her.
Pardon?
I threw sand. I threw sand at her.
You threw sand at her, so
Yes.
you threw something at her?
Yes.
Okay, and who is she to you?
That's the mother of my son.
Okay, so you have a child in common?
Yes.
All right. And you didn't have her permission to do that, did you?
Uh,
All right. And you did it intentionally?
yes.
All right. If I accept your plea and you commit misconduct between now and the time of sentencing as defined by the Michigan court rules, any sentence agreement or evaluation, the court is no longer bound by, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or inducements which have caused this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with
Throwing
the court?
sand?
Yes, Your Honor.
Yes.
I feel
Alright,
like
court
this
will
has
accept the
more to the
defendant's plea.
story than just throwing sand.
I'm guilty to this charge. Defendant is referred to probation, pre-sentence investigation and report. He is set for sentencing on that other case on the 18th.
Yes.
Is it?
That's correct.
We can do the 18th. Pardon? Yeah. Sentencing in this matter will be August 18th, 2025 at 1 p.m. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you.
Right, thank you. Court does call the case of the people versus Ali Hayeri.
Ali Zend on behalf of the people, Your Honor.
Your Honor, good morning, Joe Simon on behalf of the defendant. State your name, Ali.
Ali Hayeri. Yes, Your Honor.
Your Honor, today is the date and time set for final settlement conference. At this time, the people are unable to proceed.
Accordingly move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
All right.
Your Honor, request that the court check the box returning prints and arrest data.
I don't have the. I don't have a dismissal.
Okay, I can prepare one for the court. Thank you.
Yeah. All right. Right. The off.
Court calls the case people
motion and
versus
off you
Robin
start, Mr.
Muhammad.
Ali.
Oh, they just called for him.
Ali Zend on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Muhammad.
He's coming out. I may have called it a bit early. Weidling, why was he up there trying to talk to you?
Mr. Simon?
No.
He always talks.
No, this one. I'll talk to Don't talk to him. You can talk to Joe. Talk to him. Ramin Muhammad. He just came up there. He looked like he was up to something.
Okay. Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Muhammad. State your name for the record, please, sir.
Rahman Muhammad.
Thank you.
Your Honor, today's the date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed,
Okay,
this case
another
is
one.
dismissed. That is without prejudice. Thank you.
Thank you.
Court calls the case people versus Tierra Peterson.
Ali Zend on behalf of the people, Your Honor.
Good morning, Your Honor. Tina Sachs on behalf of Ms. Peterson's and son.
What?
And son.
Son?
Unfortunately, she wasn't able to secure
She was what?
childcare. She wasn't able to secure childcare. We know this is a dismissal.
Want me to punish her for bringing baby?
Absolutely not. He's
Oh,
Jewish.
all right. I didn't know what you want. How old?
10 months.
10 months? Oh. See, now I can be in a good mood.
That's what I said.
Huh?
I said the same thing.
I know, I'm a sucker for babies. But don't everybody be bringing you.
I was like, I'm always having a baby on my hip for now on.
Some of them don't know how to behave. This is much like my staff. All right.
Your Honor, today's the date and time set for final settlement conference. At this time, people are unable to proceed.
Your Honor, defense moves for dismissal.
People being unable to proceed, this case is dismissed. That is without.
Thank you, sir.
Thank you.
Oh.
Court does call the case people versus Elizabeth Raget.
Conrad Silver on behalf of Pittsfield Township.
Good morning, Your Honor. Sam Bernstein with and on behalf of Ms. Raget. Ms. Raget, could you please say your name to the court?
Elizabeth Raget.
She's gonna enter a plea
Yes, Your Honor.
to OWI, is that correct?
Yes, Your Honor.
That's correct. All right. May I have her sworn?
You solemnly swear or affirm the testimony you're about to give the truth, whole truth, and nothing but the truth, help you God.
I do.
Lower your hand and say your name again.
Elizabeth Raget.
All right. Ma'am, it is this court's understanding that you're gonna plead guilty to the charge of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Court could order community service or any rehabilitative services the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do, Your Honor.
Do you still wish to plead guilty?
I do, Your Honor.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I do, Your Honor.
All right. You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights?
No.
All right. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
Yes, I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today
No, Your Honor.
to get you to plead to this?
Right.
Sorry.
I understand.
Has anybody threatened you or coerced you?
No,
You're doing this voluntarily?
I am.
Of your own free will?
Yes,
And because you believe that you are indeed guilty of this offense?
I am, Your Honor.
On the date of March 27, 2025, at the location of Carpenter Road, Pretrial Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
I did.
What did you have and how much?
I had about almost 2 bottles of wine.
Right. Were you stopped by the police or was there an accident?
There was an accident.
What happened?
I pulled out, and I misjudged, and I went directly into another vehicle. It was trying to turn left. I'm really sorry.
Did the police arrive?
They did.
Were you taken to the hospital?
I was.
And was there a blood test?
There was.
And the blood test was 0.191?
Yes.
Oh,
Do you have any reason to dispute those blood tests?
No.
0.191. Oh, she was fucked up. What is the legal limit? 06? 0.06, 0.05 in Michigan, Dave? And she was almost at 0.2. Yeah. 0.08. Okay. So 2.5 times the legal limit. Yeah, that's kind of hard to reach. I mean, if you see in my slightly bust Friday streams, I don't get there, and I'm pissed sometimes. I'm pissed. In European slang, that means really drunk.
Ma'am, you understand that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea and any sentence evaluation or recommendation the court would not be bound.
I understand, Your Honor.
Counsel, have there been any other promises, threats, or inducements that you're aware of that have led to this plea?
No, Your Honor. No, Your Honor.
All right. And have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
August 27th at 12.
August 27, 2025, noon. All right.
Could I just bond, Your Honor?
Yes, you may.
Ms. Raget has, she's been in jail for 3 weeks now. Obviously, tell by her demeanor that candidly she has struggled with alcohol. That's something that she's very well aware of. She knows that she needs help. She had signed up for the Trinity Addiction Services program prior to her incarceration. It was a 3-day-a-week program that would involve counseling and group sessions, and she thinks would be really beneficial for her. We talked about the plea form, and specifically if she were to be given the privilege of release, any sort of drinking behavior would likely result in jail incarceration rather than probation. So she's pretty well aware of that, Your Honor. She has pressing family concerns that she's hoping to get back to in the world, an ill father, and a son as well. So she has some responsibilities she's very, very eager to, and I can tell she's actually quite ashamed at her behavior, and she's hoping to get help, Your Honor. So she's asking for the chance to be released and prove to the court that she can get herself to that program and follow through on that.
Was she originally on a PR bond?
Yeah, she had bond violations, Your Honor.
Yeah, that's what I thought.
Oh, so first bond, violated bond, sent to jail. Yeah.
She was on a sober list.
Yes.
All right. And then had the violations. All right. Anything from the people regarding this?
Your Honor, if the court is considering releasing her, the people would request a scram.
When would you get yourself enrolled in the program?
I am enrolled.
You are enrolled?
Yeah, I had an appointment on the 28th and I couldn't attend because I was here, but they're just waiting for me to get out so I can get back.
And that's the Trinity addiction?
Trinity Health is 3 days a week. Yes, and that also includes testing, Your Honor.
What I'm going to do is I'm going to give you a shot.
Thank you.
It's going to be up to you though.
Okay.
So I'm going to reduce her bond to a personal cognizance of $25,000 fine. Defendant is to be placed on a scram tether unit prior to her release.
Thank you, Your Honor.
All right. I did not expect this leniency,
Right.
but
See
he's
you
there.
set.
I'm here.
Right.
And
And Mr. Bernstein is right. That if you violate, it's going to be a jail sentence.
I understand.
Thank you. Court does call the case, People versus Brittany Williams.
Allie Zend on behalf of the people.
Yes, Your Honor, we plead this honorable court.
I told you to call it. I told you not to talk to him, but I said I didn't want his case called either.
Oh, I missed that part.
No, him and Mac, they're supposed to be waiting here all day. No, it was him and Mac. It was. No, Sam could go. Yeah, Sam's fine.
All right, thank you. Brandon Bird on behalf of Brittany Williams. Ms. Williams, can you please state your full name? for the
Brittany
record?
Marie Williams.
Thank you.
Your Honor, today's the date of time set for final settlement conference. At this time, you are unable to proceed.
Respectfully request dismissal, Your Honor.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
All right,
You
thank
and
you.
the honorable court have a great one.
You do the same. That's it for you?
That's it for me today.
Really?
Yeah, really.
It's always a pleasure seeing you every day.
Thanks, Bird.
No, I mean that from the bottom of my little heart. All right, take care. Court does call the cases of the People versus James Raget.
Allie Zend on behalf of the people, Your Honor.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Raget. Mr. Raget, please state your name for the record.
James Patrick Raget III.
Thank you.
And Your Honor, today's the date and time set for final settlement conference on our file, and at this time, people are unable to proceed.
In both cases?
Just the 9/20.
923. Okay, go ahead.
Move to dismiss, Your Honor.
People being unable to proceed. Case ending in 0923. That case is dismissed. That's without.
On the other file, Your Honor, that is the IBAC case.
Yes.
Your Honor was willing to have the file today, given the potential of a dismissal today. He's being held on bond denied because of the domestic violence case that was picked up. Given that the case has been dismissed, I would ask that the court consider reinstating his personal bond. He has been on a scram tether since January of this year. He's had no alcohol or drinking or tampering violations on that tether. He was just picked up on again, the domestic violence case. If the court is willing to release him today, he is asking the court to consider giving him a sober link. He, as I said, he did have no violations on the scram. He's been on it, well, been in custody for a few weeks now, but before that, no violations on the scram. He works with bikes, like literal pedal bikes. He runs both the non-
As opposed to what other kind?
Sometimes I think electric bikes. Yeah, there you go.
Motorcycles.
Yeah.
Sometimes people think motorcycles.
So he works at a place that sells bikes, and he also runs a nonprofit for children. So teaches young people how to ride bikes. So he's asking a sober link just because the scram can get in the way of pedaling.
Can get in the way of pedaling?
So I have more information if the court wants. So because he has tattoos on his legs, the device that detects.
No, you keep going because I don't know who's buying it, but go ahead.
The device that detects or tracks the skin has to be on clean skin, I guess, for lack of a better phrase.
No,
non-tattooed skin. And the only place that can be is the inside of his ankle.
Oh.
I would like to hear that from somebody who works with
He's
it.
done very well on it. I want him to continue to do well.
They no longer have it on you, sir? No. It's all right.
Okay. So he will be he have to
We are
walk
set for
wide-legged.
September 17th on this case.
Yes, Mr. Raget is going to get a assessment done. I think we set it out that far. So if he were to be released, then he can get that done, get it to the people for consideration of a reduction.
All right. What I will do is I will reinstate his previous bond. However, he has to be on a scram tether prior to release. I understand that he's done very well while on the scram, but I'd want that. I do recognize also that his blood alcohol was a 0.31. So
holy fuck.
A scram tether is just right in this case. All right. All right.
Thank you, Your Honor.
Thank you.
0.31. That's dead. I mean, Jesus Christ.
You're gonna need this. Court does call the case of the people versus Keith Davis.
Ally's done on behalf of the people, Your Honor.
What?
Okay.
You know, I told you, leave that. They never listen. They never listen.
Judge, for the record, I'm listed on the multiple names, so it's not their fault. It's not their fault. Good morning, Judge Simpson. Hugo Mack appearing with Mr. Davis. And just a record, I want to know my client's wearing long pants today. And
yes.
In recognition, the National Weather Service did cancel the flood warning. So we're in good shape here.
Good shape. Your name, sir?
Keith Davis.
All right.
Your Honor, today's the date time's up for final settlement conference. At this time, people are unable to proceed.
Your Honor, make a motion to dismiss.
People being unable to proceed, this case is
All right.
dismissed. That is
Another
without.
one.
Thank you so much, Judge.
Congratulations. Off you go.
Have a great day.
Thank you. Take care. The court does call the case, people versus Paris Calloway.
Conrad Silver on behalf of the township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Calloway. Mr. Calloway, please state your name for the record.
Good morning, Paris Calloway.
Thank you.
Your Honor, this is the date time set for final settlement conference. People are unable to proceed. I did have a plea offer with Mr. Calloway as well. on record that he's rejecting that plea offer.
All right.
Is that correct, Mr. Calloway?
Yes.
All right.
Move to dismiss, Your Honor.
People being unable to proceed this case.
So they gave him an offer, he declined it, and then they dismissed it. Okay. That's kind of a bit murky. I mean, if you don't have enough, just dismiss the fucking case. Don't give him an offer just to get a point on the record.
Is dismissed. That's without.
Thank you, Your Honor.
Thank you.
Court calls case People versus Maurice Cahey.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Cahey. Mr. Cahey, please state your name for the record.
Maurice Cahey.
Thank you.
This is date and time set for final settlement conference. People unable to proceed.
Move to dismiss.
People being unable
Okay.
to proceed this case is dismissed. That is without.
More dismissals in this,
Thank you, Your Honor.
All right.
on
Thank
this
you.
date.
Court calls case of the People versus Thomas Bennett.
Allie Zend on behalf of the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Bennett. Mr. Bennett, please state your name for the record.
Thomas Bennett.
Thank you.
Your Honor, today's the date and time set for final settlement conference. At this time, the people are unable to proceed.
Move to dismiss.
People being unable
number
to proceed
5.
this case is dismissed. That's without prejudice.
Have a good day,
Thank
sir.
you.
Court calls the case People versus Nicholas Bonsanek.
Allie Zend on behalf of the people, Your Honor.
And Assistant Public Defender Natalie Pate on behalf of Mr. Bosnack, who should be present via Zoom.
Why is he?
Yes.
Oh, it's my Kiwi. Yeah.
Hi, Ginger. Good to have you here. Good to have you here. So we're up to 5 dismissals.
So sorry, Assistant Public Defender Natalie Pate now with and on behalf of Mr. Bosnack. Mr. Bosnack, do you mind turning on your microphone and stating your name for the court if you can hear us?
Full name Nicholas Michael Bosonic III.
All right. Thank you, sir.
Your Honor,
Thank
today's date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to
Number
proceed
6.
this case is dismissed. That is without prejudice. All right.
All right.
Sir, thank you very much. Take care of yourself.
Thank you, Your Honor. Thank
And
you.
all those down in Kiwi land. Eh?
Thank you very much.
Take care.
Thank you, sir.
You have a good day.
You too.
Bye-bye.
Court calls the case. People versus Jason Brooks.
Allie Zend on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Brooks. State your name for the record, please, sir.
Jason Brooks.
And Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
Number
People being
7.
unable to proceed this case is dismissed. That is without prejudice. Thank you, sir. Thank you.
Number 7. Okay. Yeah, from an earlier discussion, Google says there's no evidence that a tattoo in itself will interfere with the function of a SCRAM or GPS ankle monitor. The technology is designed to work with the natural properties of the skin and does not rely on skin color or the absence of ink. Yeah, it sounded really, really strange. Is this entire day of dismissals? I mean, I'm happy for them, but I don't know if it is really interesting.
Court calls the case of the People versus Jemina Byers. Yeah,
Allie Zend on behalf of the people, Your Honor.
I think it's J. Jamoya. I give up.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Byers. State your name for the record, please.
Dejamoye Byers.
Your Honor, today's the date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to
number
proceed,
8.
this case is dismissed. That's without prejudice.
Thank you.
Okay, I think we can speed this up to 1.25.
Court does call the case People versus Ashton Eagler.
Haley Zed on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with on behalf of Mr. Ebler, who is approaching. Please state your name for the record, sir.
Ashton Eagler.
Your Honor, today's date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
Number 8.
People being unable to proceed, this case is dismissed as without prejudice. Thank you. Court calls case of the People versus Marquand Gracie.
Haley Zed on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Gracie. Mr. Gracie, please state your name for the record.
Marquand Q. Gracie. Thank you.
Your Honor, at this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is
Number
dismissed. That is
9.
without prejudice. Thank you, sir. Thank you.
What's going on here?
Court calls case People versus, is it Hishar Isa?
Haley Zed on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with on behalf of Mr.
Good morning,
Issa,
Your Honor.
who stands to my right.
Good morning, sir. State your name. Charley, Isa.
Your Honor, today's date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed as without prejudice. Thank you, sir.
Number
Thank you, Your Honor.
Okay.
Court calls case of People versus Douglas Lee.
Haley Zed on behalf of the people.
Did they purposely took everything?
Assistant Public Defender Natalie Pate with on behalf of Mr. Lee, who stands to my right. Please state your name for the record, sir.
Douglas Lee. Thank you.
Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
Motion to dismiss.
People being unable to
Number
proceed, this case is
11.
dismissed. That's without prejudice. Thank you, sir.
Thank you, Your Honor.
Court calls case People versus Jaquil Lloyd.
Haley Zed on behalf of the people, Your Honor.
Good morning, Your Honor.
Assistant Public Defender Natalie Pate with on behalf of Mr. Lloyd, who stands to my right. Please state your name for the record, sir.
Jaquil Lloyd. All right. Put your hands up. I'm sorry.
Your Honor, today's date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you,
sir. Thank you.
You sit there.
11.
Why'd you shake her hand? She didn't do anything. No, I'm kidding. Court calls the case People versus Adriana Taylor Hamby.
Haley Zed on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Taylor Hamby. Say your name for the record.
Adriana Taylor Hamby.
Thank you.
Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
12.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you. Thank you, Sandy. Take care.
Thank you.
Honestly,
Bye. She on her way. Bye. Brennan. Court does call the case People versus Ronald Altman.
Haley Zed on behalf of the people, Your Honor.
And see counsel back there. Okay.
Morning, Your Honor. Don Smith on behalf of Mr. Altman.
Your name, sir?
No,
Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
No, we asked that the matter be
13.
dismissed.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you.
Thank you.
Take care.
I thought somebody said
Court calls the
this
case
day
of
was
People
the
versus
day
Isa
for
Alba.
heating up.
Haley Zed on behalf of the people, Your Honor.
Good morning, Your Honor.
Jeffrey
Good morning.
Bledsoe Ford, Jeffrey Joby Bledsoe Ford on behalf of Isa Awad.
Okay.
Your Honor. Oh. My
Your Honor,
client
today's-
is here today. I don't know if oh, go on.
Your Honor, today is the date and time for the final settlement conference. At this time, I would be asking for an adjournment of the final settlement conference. We were attempting to reach out to the victims and found out the number that we had was just for the business that they worked at. And when we were finally able to make contact, we found out that both of our victim and witness are either out of town today or getting medical treatment for something. So we would ask for an adjournment so we would have a chance to speak with them and discuss this case.
Response?
No objection.
All right.
Okay,
State your name,
so
sir.
13 in a
All right,
row
thank you.
before the
What I'm going to
first.
do, sir, is I'm going to adjourn your case. I'll adjourn the jury final settlement conference. We'll set a new one for October 17th, 2025 at 9. And then jury selection in this case, October 20th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
All right, thank you.
Thank you.
Thank you.
Bye.
Thank you.
Okay. All right, no, that's fine. It's there. Oh, you printed it for.
Forms engine.
Got it. He's here.
And that's him right there.
Okay, so they're waiting. All right. Court stands in recess. I'll stay seated.
Okay. And they are
I
back.
can wait for him.
Court does call the case, Gulfside Lake versus Paul Zigbetzla.
Morning, Your Honor, Jillian Aiken for plaintiff.
Your name, sir?
Paul Gottschalk.
Nice to hear. All right, where are we on this case?
Your Honor, the parties have reached a conditional order of dismissal, and so we can place the terms on the record.
Yes.
Thank you, Your Honor. This is a case for termination of tenancy, and this matter is going to be dismissed without prejudice, subject to the terms of the order. Defendant Paul Gottschalk shall vacate the leased premises. I'm not going to put the address on the record, and shall turn in keys on or before September 15th, 2025. As of August 8th, 2025, defendant's balance with plaintiff is $3,022.13, which includes court costs of $172. Defendant shall pay the arrearage of $3,022.13 as follows: $1,069 on or before August 8th, 2025, and defendant shall pay the remaining arrearage plus the final utility bill and prorated September rent in monthly installments of $500 commencing October 15th, 2025, and continuing each month thereafter until the arrearage is paid in full. It's not in the order, but if Mr. Gottschalk misses a payment, his account is going to be sent to collections. That will resolve that. The defendant shall comply with the terms of the lease. Plaintiff shall provide a neutral landlord reference if contacted about defendant by a prospective landlord. And then in the event the defendant fails to comply with the terms of this order, plaintiff will be entitled to an immediate judgment for possession with a writ of restitution and an order of eviction to issue immediately upon the filing of an affidavit of noncompliance with the court without hearing but with notice to defendant via mail. On the copy that I submitted to the court, it included a provision 8, and Mr. Gottschalk is requesting that be stricken from the order. I can delete it. Okay,
go ahead.
I can delete it and then resubmit it.
Okay.
So that it does not include that. I've provided.
What is the provision 8?
It says defendant specifically waives the 14-day notice and objection period set forth in MCR 2.602 C2D. I think Mr. Gottschalk is concerned about waiving rights that he doesn't necessarily hasn't looked into what he would be waiving.
But he waived. All right. All right.
And then we did go over MCR 4.201J, but I'm hoping that can be placed on the record as well.
All right, sir, is all of that correct?
I believe so, yes, sir.
All right. Is there, just look at this. Do you have any questions or concerns regarding any of the provisions other than paragraph 8? And I'll get to that in a moment, but
I don't.
No? Oh, all right. Okay, and sir, why don't you lay out for me what's your issue with paragraph 8?
Well, it appears that I'm giving up a 14-day notice right that I don't understand, and that wasn't really part of the discussion when we came to this agreement.
Okay, and that's probably because most of the time that these are coming through, that's waived. So so that you understand what that. I'll give you what the legal effect is and what the practical effect is. Okay. All right. So normally what would happen if there's a violation in some respect, you would be entitled, they'd have to send you notice. You get 14 days notice regarding that before anything could happen. Okay. While that's there, the practical effect of how things work is that, let's say, just hypothetically, there's a lease violation, say the 31st, before the move out date. Say September 1st, okay, just picking a date. And they file for their judgment and order of eviction. You still have a mechanism by which you could get before the court. That's the practical effect. You just don't have that 14-day period. So if you believe they're wrong, you can file a motion with the court to be heard and you'd be heard. That's the practical effect of how this operates. Okay. So while I understand the waiver of the 14 days, not so much. Here's part of the problem and why it's also included, okay? Because in particular on the cases such as these where there is the move out date. All right. Technically, come September 15th, because I think you're supposed to vacate by the September 6th. Well, technically by September 16th, the plaintiff theoretically, in order to get possession of the premises, would have to wait another 14 days. But what they've done is they've already given you the time to move. All right. So that's probably the best that I can explain it as to what it is and why the plaintiff would want it. Why, from the tenant side, yeah, it's waiving that 14 days, but really, it's not like you wouldn't be able to get before the court to have whatever issue you had heard. So
This landlord has been very unfair about claiming violations. Very minor things that could be handled by a reminder. He has levied his own fines and fees.
Gotcha.
With a rapidly escalating.
Why don't I do this? What if I did this to paragraph 8? Maybe it solves both problems. Okay. What if I just said you're waiving the 14-day notice and objection period only as to the September 15th move out date?
Fine.
So that if it's anything else, you get the 14 days. How's that sound?
I'm very good with that. Thank you.
Okay.
Your Honor.
Your Honor, that's satisfactory, Justice.
All right. This seems to be the last one of this one. Now you can always go to Judge Simpson's page. For once, he actually have most of the week still up. Normally, he deletes the same day. So it's still up there.
I've added that to that.
I haven't had, my week has been absolutely swamped. I haven't had time to record any of this week's recordings. So hence this, well, live reaction, since I can't produce anything to my other channel.
I need to hand this to you guys because I'm going to need signatures for all of that. And sir, when they give that to you, you have 3 business days from the time that I sign it to think about this. If you believe that there's some right you have to assert, some confusion on your part, or some other type of misunderstanding, you'd have those 3 business days to think about it, file a motion with the court in that time frame. Doesn't mean I grant it, but you have that time frame to do that. Okay?
Okay, so we finished off with the landlord case. Yeah, that's the final one. What is the next case I'm covering? Well, I will keep reading from the Delphi transcripts, where tomorrow for 10 a.m., me and Mo will continue reading from volume 4, the May, let's see here. Well, May 17th, I want to say, from 2024. Also, going to do a bit more on the Laura Owens case. I believe there is a hearing tomorrow. I don't know if it is streamed, though. And then you have the trial of Donna Adelson starting the 19th. So, and now there won't be a YNW Melly trial. That is postponed to 2027. Because the Florida Supreme Court ordered a stay. Since they need a resolution to all the things with attorney Raven Liberty. So there's a stay on that until 2027, because the current judge does not have time in his docket the entirety of 2026. So I will be covering the Donna Adelson trial, which begins August 19th. Now, it won't end until after I am in the United States, so I will try to figure something out there. But other than that, I'm not entirely sure. I will continue with the trial transcripts and maybe a reaction, because somebody did a new of the one of these YouTube shrinks did they cut out a portion of the Zachariah Anderson case during the sentencing, and then they did, that the thing that Dr. G did, making conclusions out of something out of context. So I'm probably going to do a reaction to that one as well. But that is in the near future. So folks, this was all I had for you this beautiful Sunday. You all have a good one from me and Mr. Jingles. You all have a good one, and I will see you all in the next stream or video. Okay, see you. Bye-bye.
Sail the raven waves, brothers.